The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications, basically about how limited constitutional government based on the rule of law can have a positive effect on public policy and law. And tonight we're fortunate to have Radley Balco come speak to us on his new book, The Cadaver King and the Country Dentist. For those of you who read his first book, The Rise of the Warrior Cop, America's growing domestic police forces being militarized, that was a great book. This one's even better. Plus, the intro is written by John Grisham. For those of you who have not read Radley, he's a fantastic writer. He writes just like John Grisham. He really does. And except what he writes is all true. I know that John Grisham had written An Innocent Man, which was a very good book. But Radley, it's really a fantastic book, and I encourage you all to read it if you can. It's also on Audible, and there's an audio book you can listen to too, and it's very good. For those of you who do not know, Radley has written it for right now you're writing for the Washington Post as a blogger. The Watch, it's a civil rights blog piece that you write routinely.
Yeah, it's daily reported blog. I do commentary and then longer reported stories.
And before that, you were at Cato for a little while, weren't you, as a policy analyst?
Cato, Reason Magazine.
Reason Magazine, that's right. Huffington Post.
Wrote for Fox News.
And Fox News. That's right. Speaking of which, he's been on BBC, CNN, CNBC, Fox News Channel, NBC, NPR, and I don't think he ever was on the Uncle Bunky show, but maybe he'll tell you a little bit about Uncle Bunky today. All joking aside, this is a tragic story. The book, and he'll tell you about it, focuses on two gentlemen who were wrongly arrested, convicted, and one was even sentenced to death based on dubious pseudoscience of a doctor and a dentist. The doctor is referenced as the Cadaver King, who during his heyday did several thousand autopsies a year, and the country dentist was a dentist in Hattiesburg, Mississippi, whose bite mark evidence was used to wrongfully convict many people, and some of whom are still incarcerated. You'll hear exotic stories about the bologna sandwich case, which is in the book. You'll hear about how it took, in some cases, criminal defense attorneys to solve unsolved murders, which is quite remarkable. You'll hear stories about a surreal car ride with two wrongfully convicted defendants going to the sentencing of a man who actually committed the murder and their testimony. You'll hear a story about a district attorney who turned on a victim, and just an incredible set of circumstances. Radley first talked about this when he came down several years ago when he was covering the Corey May case, where a SWAT team entered the wrong residence and Corey shot and killed one of the officers as they came in his door. He was protecting his child, and one of the state's star witnesses was one of the doctors mentioned in this, who offered testimony that was remarkable in its stretching of any reasonable sense of the truth. But he's been working on this thing for over 10 years, covering. That's where he first noticed this doctor. And Tucker, and I should mention Tucker Carrington because he played a big role in this. Is he a lawyer with the Innocence Project out of New York?
No, he actually runs the Mississippi Innocence Project at Ole Miss Law School. So.
And he co-authored the book with you, and it was just I want to read one little part of it, and then I'm going to turn it over to Riley. I'm going to quit talking. But in Grisham's introduction to the book, or forward, he says, "As you turn the pages, you will often be tempted to close this book and either laugh or cry or yell that what happened in Mississippi cannot possibly be true. But it is. It happened in plain view and with the complicity of many who were sworn to uphold the law." So y'all please join me in welcoming. I can't get this thing keeps falling on me. Sure.
Thanks, Matt. Thanks to Federal Society for inviting me to give this talk.
Had a great time last time I was here. See if I can figure this out here. So I think it's probably going to pop off. So I think best thing to do is I'm just going to give you kind of an overview of what the book's about, and then I'll do a few readings, and then we'll open it up to question and answer. That's usually where people usually have really, really interesting questions. So Matt kind of outlined the basics of the book, but so the book has four kind of central characters, I guess. There's the Cadaver King and the country dentist. The Cadaver King is Stephen Hayne, who for about 20 years did about 80% of the autopsies in Mississippi. And as Matt pointed out, that boils down to somewhere between 1,500 and 1,800 autopsies per year. To give you an idea, the National Association of Medical Examiners says no doctor should do more than 275 autopsies a year. If you do more than 325, they won't certify you regardless of the other circumstances. So Hayne was doing 1,500 to 1,800 per year, which nobody really, before that there was a guy in Texas named Ralph Erdman who was doing about 500 per year, and he was considered sort of the poster child for excessive autopsies. For most of his career, Hayne also held down two full-time jobs in Mississippi, one at a kidney research center and one at a local hospital. So he did all of his autopsies at night from the basement of a morgue, and he did them from about 5 p.m. to about 2 or 3 in the morning. He and Dr. West, who's the country dentist in the book, who I'll introduce you to, would do these autopsies with maybe one or two other people, but Hayne was really the only licensed doctor there. And from people I've talked to who actually visited the facility during one of these all-night autopsy sessions, it's pretty gruesome. They would have 3 or 4 bodies open at once. They would smoke cigars as they were doing autopsies. I interviewed one former state director of the state crime lab, who was actually hired from out of state to come in and clean up the crime lab and get it accredited. And he said the first time he visited Hayne's practice at this morgue, he said he sent all of his assistants home because he didn't want them to see sort of the unprofessionalism on display. And he told me, and unfortunately the lawyers at my publisher wouldn't let us use this quote in the book because this particular person wouldn't go on the record, but or he wouldn't speak for attribution. But he basically said, I remember the quote verbatim. He says, at some point in the evening, they decided they were hungry, and so they sent out for pork sandwiches. He said, so I sat in disbelief as they were eating pork sandwiches and smoking cigars as someone was running a bone saw on the skull of a crack prostitute. So you can imagine there's several bodies open at once. They're eating and smoking as they're performing these. So it's not, it wasn't the most hygienic situation, but it also was a lot of disrespect for the dead. And also, this is not the way to sort of do autopsies in a way that is going to keep the evidence in pristine condition. Dr. West, who I'll introduce you to in a minute, started out as a bite mark guy, a bite mark expert. Bite marks are a very sort of dubious field of forensics already. West would become sort of a pariah even within this already dubious field of forensics. Then it would sort of expand and become a kind of a forensic jack of all trades, to the point where he was doing video enhancement. He called himself a video enhancement expert. He called himself an expert on tool marks, an expert on blood spatter analysis. At one point, he offered, in one particular trial, he offered his expert opinion on the way that lesbians fight when they get into arguments. He claimed he had expert opinions on that. They were fairly bigoted opinions, as you might imagine. And eventually we find out that West, in a lot of these bite mark cases, we see he was actually recording himself doing some of these examinations with the bite marks. And after a couple of exonerations, we started to get copies of these videos. And he actually recorded himself because he was marketing his services to prosecutors around Mississippi and Louisiana. And in several of the videos, which I have copies of, he actually takes the dental mold of the suspect and he jams it into the body, into the corpse, over and over and over again. And experts we've asked to look at these videos say that he's actually creating the bite marks that he would later use to implicate these people. Remarkably, some of those people are still in prison. That's kind of the introduction. Oh, well, I got to tell you about the other two. So the other two main sort of characters in the book are Levon Brooks and Kennedy Brewer. These are the two men whose convictions kind of drive the narrative in the book. They were convicted of crimes that were committed about a year and a half apart in Noxubee County, Mississippi. And both these crimes were remarkably similar. This is a rural part of Mississippi that didn't see much of this kind of crime at all. Both cases, a young girl about 3 years old was abducted from her bedroom at night, raped and murdered. Levon Brooks was the first to be convicted, and basically they fixated early on Brooks for, we get into the book sort of why, but because of a lot of mixed up cases, including one in which Uncle Bunky, a children's TV star, interviewed the only 5-year-old witness to the crime, and they sort of took her testimony and ran with it.
Kids loved him. He
Yeah.
wrote the cartoons.
That's right. He would do these little illustrations for kids. But they fixated on the wrong guy. They brought in Hayne and West. Hayne did the autopsy, found bite marks, brought in West. West then matched the bite marks to Levon Brooks. In that particular case, one of the suspects was the guy who actually committed the crime, and West exonerated him. West actually looked at the bite marks and compared it to the actual murderer's teeth and cleared him. And that was because the authorities had already fixated on Levon Brooks. And Michael West's job was not to actually find who committed the crime. It was to basically confirm the hunches of whoever the police and prosecutors thought committed it. So about a year and a half, 2 years later, we get a remarkably similar crime. Kennedy Brewer is, again, in both cases it was a boyfriend of the mother of the victim that the police fixated on. Again, they bring in Hayne. Again, Hayne claims to find bite marks. He brings in West. West matches them to the chief suspect. Kennedy Brewer gets convicted. Levon was sentenced to life in prison. Kennedy was sentenced to death. Kennedy was actually cleared by DNA testing in the year 2000. But the prosecutor in the case, Forrest Allgood, said, well, all the DNA shows us is that he didn't rape the little girl, but we have this bite mark evidence that clearly implicates him, so he must have held her down and bit her while somebody else raped her. So Kennedy would stay in prison for another 7 years. Finally, in 2007, they checked the DNA profile from one of the crimes against the state DNA database, or the FBI database, actually. And they get a hit for a guy named Justin Johnson. And Johnson, in 2007, confesses to both crimes. Didn't bite either little girl, actually, so the bite marks weren't even human bites. They were insect bites from what we can tell. The problem is Hayne, again, testified in about 80% of the homicide cases in Mississippi over 20 years. West testified, so Hayne testified in thousands of cases. West testified more like dozens. However, West, they worked together, and West was sort of insistent at most of Hayne's autopsies, in fact, worked for Hayne for a while. That's kind of the gist of the main plot. We also kind of get into the history of the coroner system in the United States, and in Mississippi in particular. It has kind of a fascinating history. You are all legal people in this room, so you probably know the difference between a coroner and a medical examiner. A lot of people don't. We get into kind of that history in the book. And we talk a little bit about the death investigation system in general and how it's sort of a leftover from the segregation era, the Jim Crow era. And sort of the implications of that system is still kind of the system that we use today.
You mentioned Emily Ward, our Mobile connection.
Right.
She's using the book.
So both Emily Ward and Leon Riddick, who are both Alabama state medical examiners, appear in the book. So Riddick testified against Hayne in many, many cases, including the Brooks and Brewer cases. He submitted affidavits that helped eventually free Kennedy and Levon. Ward actually is from Mississippi originally, and in 1992, I think, or 93, I want to say.
June of 93.
Of 93, she was appointed state medical examiner in Mississippi, and she was alarmed by what was going on in Mississippi and tried to actually clean the system up, and was promptly basically run out of the state on a rail. Hayne and West basically got the coroners together, kind of a good old boy system, the coroners, and eventually circulated a petition that demanded her resignation. It's a kind of a crazy story. They really went after her, attacked her personally, because she kind of, she threatened this little kind of fiefdom that they had set up.
Bull D?
Yeah, a sheriff down there called her that, yeah.
Pretty
Yeah.
ruthless, like you said.
Yeah, ruthless. They were ruthless. So, the things that we kind of wanted to go to, or we were hoping to accomplish in this book, one is, my co-author and I had been working on this story for about 10 years as a journalist. He had been working for about 10 years as an attorney. And we would talk on the phone, I don't know how many times, dozens of times over the years, and kind of occurred to us that, at most I could get 5,000 or 6,000 words to tell one part of the story, right? One case in particular. And it was frustrating because it wasn't, you couldn't sort of tell the whole story with all the proper context and the way that it needed to be told. And so one reason we got together to write this book is because we were kind of the only people who knew the full story, and we just wanted a record of it. This story needs to be down somewhere for posterity. But also, there are still people in prison who are convicted, thousands of people convicted by Hayne. There are at least 2 people on death row who I believe there's a very good chance that they're innocent. At the very least, there wasn't enough evidence to convict them, or the evidence was tainted. And in the Mississippi, they've never really done an audit to see just how much damage these 2 guys did. Nearly everybody in Mississippi now admits that Michael West was a fraud. To this day, the Attorney General of Mississippi, Jim Hood, defends Stephen Hayne. He'll defend him, right now if you called him up. Insists that he was a competent and credible witness. Might have something to do with the fact that Jim Hood used Hayne when he was a DA in a lot of murder cases. So to admit now that he was a problem would be to admit he had screwed up a lot back when he was a prosecutor. But also we wanted to just, one theme that runs throughout the book is sort of the use of forensics and the way that the courts have allowed junk science forensics to kind of infiltrate the criminal justice system. And not to get too sort of esoteric on you here, I guess, but there's a real problem between the legal system and sort of the scientific community, and that the legal system has a very definite, very prescribed way of viewing the world that comes into conflict a lot, I think, with the scientific way of viewing the world. In the legal system, we sort of look to the past to guide our behavior, right? We look to precedent, we look to controlling case law. Science is kind of constantly changing and evolving. And the problem here is when you allow bad science into a criminal trial, and we later learn that it's bad science, the criminal justice system has not come up with a good way, well, they haven't come up with a good way to keep bad science out of trials, but they also haven't come up with a good way to sort of address, after the fact, the problem of all these trials that might have been tainted by bad science. We've seen this with hair fiber analysis. The FBI admitted a couple years ago that its hair fiber analyst had overstated the significance of hair fiber testimony in almost every single case they testified in. And we're talking, this is a couple thousand cases at least over 10 years. Not only that, but they also trained the hair fiber analysts at the state level across the country. So we're talking tens of thousands of cases. They admitted recently that something called compositional bullet lead analysis was completely false. For about 20 years, the FBI claimed that every batch of ammunition that would come out of a factory had a unique chemical signature. And so if you found a bullet at a crime scene and your suspect had a bullet at his house that had the same chemical signature, they could only have come from the same box of bullets, and therefore you could basically convict that person. Turns out that wasn't true. And they admitted it wasn't true about 7 or 8 years ago. But again, we're talking thousands of cases. The sort of annals of junk science, bite mark evidence to this day, every single scientific review of bite mark evidence has found there's just no scientific evidence to support bite mark matching. The idea that A, we all have a unique bite, no science to support that at all. And B, that human skin, even if we did all have a unique bite, the idea that human skin is capable of recording and preserving that uniqueness in a way that's usable and comparable, that also, there's no science behind that whatsoever. And yet, to this day, every single time bite mark evidence has been challenged in court, it has been upheld. There hasn't been a single judge to throw it out yet, despite the fact that every scientist you interview will say there's just no science behind it. So that's kind of a long-winded introduction to the book. What I want to do is maybe do a few readings, and then I'll do 2 or 3, and I'll look and try to see how bored you are, and then we'll either do another one or we'll open it up to Q&A if that works for everybody. Let me introduce you to Hayne and West first. Feels very rebellious to drink a beer while I'm up here giving a talk. I love it.
Family.
All right, so this is the introduction to Dr. Hayne. Among the witnesses whom Park Morris has deposed over the years, Stephen Hayne sticks in his memory more than most. In October 2007, the Memphis-based attorney was representing the estate of a man who had died of dehydration in a nursing home. The family had hired Hayne to do the autopsy before retaining Morris. The opposing attorneys and Morris had just questioned Hayne in a deposition. "I'm a Civil War buff," Morris says, "so I was in his office talking to him, and I noticed that Hayne had a shelf full of Civil War books. I pulled a book off the shelf at random. I can't remember what we had been talking about, but he told me to turn to a particular page because there was a quote that was relevant to our conversation. I turned the page, and I'll be damned, there it was. I mean, the guy had a photographic memory." Morris says it was immediately obvious that Hayne was not only smart, but seemed to enjoy demonstrating just how smart he was. Others had noticed this too. In a 2013 article about Hayne, New York Times reporter Campbell Robertson wryly observed that when he tried to interview Hayne about the controversy surrounding his work, their conversation, quote, ranged from the fall of the Roman Empire to the folly of the Vietnam War. Brilliant guy, no question, Morris says. And then I realized that's what makes him so dangerous. Morris had deposed Hayne earlier that day. He found Hayne's answer surprising and more than a little disturbing. When someone dies of dehydration, Morris says, lab tests should show elevated levels of certain chemicals, such as sodium. Quote, "This patient's lab results were off the charts. I've investigated more than 2,500 nursing home deaths before and since, and I've never seen anything like it." But despite those test results, Hayne insisted instead that the patient had died of I'm going to pronounce this wrong, amitriptyline poisoning. Amitriptyline is commonly used as an antidepressant and antipsychotic, but can also be toxic in large doses. Lab tests did show elevated levels of the drug in the deceased patient, but Morris says other tests conclusively showed that the high levels are due to a process called post-mortem redistribution. After death, drugs can settle and become concentrated in certain areas of the body, and that can skew lab results. Morris found himself in an ethical quandary. Hayne's claims actually helped Morris's client, but Morris also knew that Hayne was wrong. He had previously hired 3 separate toxicologists, all of whom definitively told him that the amitriptyline wasn't a factor in the man's death. "He's just too smart not to have known. I think he calculated. I remember that he seemed to be unprepared for the deposition, but as it got going, he seemed to assess the situation, the attorneys, the parties, and what was at stake. Then he tailored his testimony in the fly to fit what he was observing. It was a remarkable thing." The two men made small talk after the deposition. When Morris mentioned his love of cars, Hayne asked Morris if he wanted to see his. Morris agreed and followed Hayne to the parking lot. Quote, "It was an all-black car, I think it was a Dodge Charger, that he had souped up to look like an undercover police car," Morris says. "Here was a short, kind of fat, 60-something-year-old man, and he's driving a car with decked-out rims, radios, and one of those spotlights that you control from the inside of the car." Morris knew that Hayne frequently testified in criminal cases, almost always for prosecutors. Quote, "It looked so out of character. Here's this little bit geeky guy driving around in this muscly, not-so-undercover cop car. It was definitely the car of a guy with a complex." Morris says he initially couldn't put his finger on what bothered him about it all. But the following morning, he read an op-ed in the Wall Street Journal detailing Hayne's mammoth workload, questionable methods, and testimony he had given in several cases that other experts said was dubious. "A chill went down my spine," Morris says. "I thought, that's it. I started to see the big picture." Prosecutors in parts of the South, they have this sort of jockish way about them. They're macho. You got the sense that Hayne latched onto him because he liked associating with them. I'm sure he made a lot of money over the years, but he also got to be one of the guys. He got to drive the cool car, and they had a smart guy who would play ball. It was all of that, combined with Hayne's intellect, that Morris found particularly alarming. "I'm not some left-winger," he says. "I'm pretty solid conservative almost across the board. But I started wondering how many innocent people this guy might have put in prison. It was a terrifying thought." According to Morris, attorneys on both sides of the nursing home case agreed that Hayne's testimony was way off base, and they settled the case out of court. Almost 9 years and hundreds of cases later, Morris still remembers that encounter with Hayne. The guy was brilliant. He managed to be both insecure and an egomaniac. I remember thinking that seemed like a really dangerous combination in an expert witness. All right, so now we're going to learn about Michael West. So Hayne was kind of, Hayne was very, very smart, as we say in the book. He was also very careful. He gave some there were a few cases where he gave some really crazy testimony. My favorite example is there was a case where they were trying a 13-year-old boy for murder as an adult. And the prosecutor's theory is that the boy and his sister had teamed up to kill the sister's husband while he was sleeping. And the theory was that maybe the husband, I think the husband, they thought the husband may have been abusive, but neither of them sort of had the guts to kill him alone. So they waited until he was sleeping, and then they held the gun together and simultaneously pulled the trigger, which may or may not be true, who knows. But Hayne actually testified at the trial that he could tell by the bullet wounds that there were two people holding the gun that fired the fatal bullets, right? There's just no way you can tell that, right? It's like saying you can tell the color of eyes by the knife wounds in the body, right? The color of the killer's eyes, right? There's just no science behind the idea that you can tell there are two people holding a gun that fired these particular bullets. That was actually the first time Hayne's testimony was ever thrown out in a murder case. But for the most part, Hayne is kind of slippery. He would give just enough sort of testimony so prosecutors could create a situation where they could sort of run with his testimony, but he always had plausible deniability to say, well, I just said it could have happened that way. I didn't say it did happen that way. Yeah, it's consistent with is how he would phrase it. And a lot of times it was way beyond sort of the expertise of a medical examiner. He gave a lot of testimony about ballistics. And it was always sort of just enough that the prosecutor could run with it, particularly in closing arguments, but not enough that he could sort of be called on it later. West, on the other hand, was just brash and cocky and arrogant and said a lot of really dumb things on the stand, really got caught up with himself and his own reputation. In the 90s, West was kind of a superstar in the forensics world. He was profiled in lots of different media outlets, some of them kind of critically, but a lot of them just kind of glowing profiles of him, and I think he really got caught up in himself. So here's an introduction to Michael West. Michael West was born on September 11th, 1952 in New Orleans. He grew up in Picayune, a town of about 10,000 in southwest Mississippi. He enrolled in 71, he enrolled at Pearl River Community College and then transferred to the University of Southern Mississippi. 2 years later, he had earned a Bachelor of Science degree. He earned his DDS from Louisiana State in 1977 and then went into the Air Force Dental Corps from 77 to 81. He then set up a dental practice in Hattiesburg in 1981. A portly man with thick fingers and a drawl as thick as sausage gravy, West was brash, ambitious, and at times breathtakingly reckless. His rapid ascent in the world of forensics from the late 1980s to the mid-1990s is a striking example of just how deferential and unskeptical courts, police, journalists, and juries could be when it came to expert testimony. Many of West's claims about his forensic ability should have been suspect to anyone willing to give some serious thought. Yet prosecutors, police chiefs, sheriffs, and others in law enforcement rarely thought to double-check them with actual scientists before putting West in front of a jury. West often portrayed himself as a sophisticated pioneer of forensics, but also an everyman grounded in common sense and folksy humility. Juries ate it up. He once told lawyers at a deposition, unprompted, that he had been reading a book about the Gnostic Christians and another on quantum mechanics. He also wasn't too fancy for a working man's beer. Quote, "While I'm drinking Miller High Lifes, I'm working on my magnum opus on why Galileo was wrong," he said. "I've just got to get the Pope to read it." This ivory tower blue-collar dichotomy also appears in West. I'm going to skip through that just for a second here. Here we go. In 1991, West and Robert Barsley received a grant from the National Institute of Justice for an experiment similar to one West had conducted earlier with another dentist. They paid married couples to bite one another and then examined the resulting wound patterns. According to West, they would pay one spouse $100 to be sedated and bitten and the other $50 to do the biting. The two dentists then used ultraviolet light to examine the marks and photograph the wounds over successive days. According to West, quote, "We were getting better images of the patterns 19 days after it was afflicted than we would an hour after it was inflicted." The West often cited the NIJ grant as an important credential. The results of experiments with Wallace and Barsley have not been duplicated by other researchers. In one article published in a law enforcement magazine in 1992, West and Barsley took this method to the next level. They claimed that they had used it to discern what had really happened during an altercation in which a man was killed with a police officer's gun. The man's family believed that the officer had unjustifiably shot the man. The officer claimed that the man had wrested his service revolver away from him and mistakenly shot himself. West and Barsley claimed that by using ultraviolet light, they found indentations in the man's skin that were invisible to the naked eye. Moreover, the two concluded that those indentations could only have come from the man gripping the police officer's gun. Even if they had inspected the man's hands immediately after the incident, this was a spurious claim, but they hadn't. The exam took place weeks after the shooting. This is the sort of claim that West would make over and over again. And he would make this over and over again. One of my favorite stories is the Larry Maxwell case, which you talk about in the book. This was a guy who had been, it was a triple murder in Louisiana, three senior elderly people who all lived together. And they focused on this guy, Larry Maxwell, who actually had an alibi. He worked at a local naval base as a cook, and he was on security camera going in and out of his job. But for whatever reason, that local authorities thought Maxwell had somehow pulled off this crime. And so they bring in West. Well, they found a knife at the home of one of the victims. No biological evidence on the knife whatsoever, but for whatever reason, they thought that this was the murder weapon. So West comes in, and he just eyeballing it. He looks at the knife, and he looks at the knife wounds in the bodies, and he says, only this knife could have created these knife wounds. Again, even with sort of the most sophisticated, testing, skin just doesn't record sort of the details of a knife like that. Now, you may be able to say, this knife, if you have a knife that's this long and the wounds are this deep, you could say this knife probably didn't create these knife wounds. You could say very broad things like that, but West said it was this knife and only this knife. Of course, that only established the knife as the murder weapon, right? Now he has to tie it to Larry Maxwell. So in this particular case, West goes down to the jail where they're holding Maxwell, and he shines this ultraviolet light on Maxwell's hands, and he puts on these yellow goggles. And this is a method that West claims to have invented over the years. Actually, Hayne helped him with it. He modestly names this the West phenomenon, is what he calls it. And he claims to find marked indentations in Larry Maxwell's palms that he says could only have come from gripping this particular knife and stabbing someone with it. Now, this is a couple of weeks after the crime, so who knows, Larry Maxwell gripped a lot of things other than that knife in this 2 weeks, including probably the bars to his jail cell. And yet West claims that he found these indentations and they could only have come from this knife and no other knife or no other object of any kind. Unfortunately, he also claimed that just before Maxwell was supposed to be on trial that he overexposed the photos that he took in the ultraviolet light, and he could not recreate this test because now the wounds had healed too much for the test to be repeated. So he went back to the jail, and he photocopied Larry Maxwell's hands on a standard Xerox machine, and he drew in the indentations with a magic marker from his memory, and he said, you were just going to have to trust him on this. This was one of the few cases where a judge threw out West's testimony, but only after Maxwell had been in jail for over 2 years awaiting trial. Maxwell then sued in federal court for civil rights violations, sued West, and a federal judge ruled that West was protected by qualified immunity because basically what he said in this case wasn't so outrageous. It was basically sort of merely a difference of opinion between experts. And he cited a letter that was written on West's behalf by a noted medical examiner in the South who said what West said here was, may have been right or wrong, but it wasn't so far outside the bounds of sort of science that West should lose qualified immunity. And that letter, of course, was written by Stephen Hayne.
It was an affidavit, wasn't it?
It was an affidavit, yeah, I'm sorry, that's right. So let's jump back into West here. According to his curriculum vitae, between 1989 and 1999, Michael West published 51 articles, made 50 presentations, and gave 84 lectures. By 1995, he claimed to have given lectures on a tour of China, at the FBI Academy in Quantico, and to detectives at Scotland Yard in England. He also claimed that his research had been monitored by the Royal Canadian Mounted Police, Israeli intelligence, and police agencies all over the world. West has published articles on a wide array of topics, although almost all in law enforcement journals, not in peer-reviewed journals. A sampling of the titles from his CV include, here's some of the titles of the articles he's written over the years: A New Method for Trace Metal Verification, A Study of Surface Topography of Footwear and Automobile Pedals, Serial Mass Murderers, A Study of Mass Violence, Confirmation of the Single Bullet Theory in the Assassination of President John F. Kennedy, A Second Look at Wax, The Hidden Dangers of Scalding, and Peanut Butter Aspiration Deaths Among the Mentally Retarded. He and Stephen Hayne collaborated on dozens of articles and presentations, often working on them together at the local Waffle House after one of their nighttime autopsy sessions. By 2006, West's CV stood at 27 pages, and he had testified more than 80 times and claimed to have investigated 5,800 deaths. Just 6 years later, he would put that figure at over 16,000. The majority of these cases were in Mississippi, but he also testified in at least 9 other state courts and 2 federal district courts. West has been permitted to influence juries on a wide range of topics, including bite mark analysis, gunshot reconstruction, wound pattern analysis, pathophysiology, blood stain analysis, gunshot residue, fingernail scratch reconstruction, trace metal analysis, video enhancement, pore pattern analysis, tool mark analysis, and photo enhancement. In civil cases, he's offered his analysis about cigarette burns on a nursing home patient and the marks left on a child's arm that he claimed could only have come from one particular ruler. On his CV, he has also claimed to advise law enforcement officials on the theory of shaken baby syndrome, child abuse, sexual abuse of children, and on the detection of accelerants in arson investigations. Few, if any, of West's articles and presentations were subjected to any robust peer review. Most were in areas where he had very little formal training or education. Michael West was either a master bullshit artist or an autodidact for the ages. Let's see. Anybody asleep yet? You're still? All right. The next two, I'll read 2 more sections, but I just want to introduce you to Kennedy, Brewer, and Levon Brooks. These are shorter, but they're important people, and we actually dedicated the book to them. Levon Brooks, one of the 2 men who was wrongly convicted, actually died about a month before the book came out. He had been out for about 10 years when he died. Died of stomach cancer, which we think he actually probably had while he was still in prison. And I'm going to start with Kennedy Brewer, and this is just a very short section on the day that Kennedy Brewer was sentenced to death. The day of Kennedy Brewer's sentences dawned bright and fair in east central Mississippi. By noon, the temperature outside edged towards 70 degrees. Brewer sat locked in a cramped jail cell on the 2nd floor of the Noxubee County Courthouse. Dressed in an ill-fitting suit, he sat and tried to avoid contemplating his fate. There was really no escaping what had just befallen him. He'd been arrested for something he hadn't done. He'd then spent 4 years behind bars waiting for the trial he thought would finally set him free. Instead, just hours earlier, a jury had convicted him of capital murder for the rape and murder of a 3-year-old girl. To make matters worse, whatever his shortcomings as a young father, Brewer had come to care a great deal for Christine Jackson, it's the victim. He thought of the girl as his own. Now she was gone, snatched from her home on his watch, then brutally violated and killed. He wanted to be sad about that. He wanted to deal with his guilt for not waking up to protect her. He wanted to mourn. But at that moment, there was no room in his head for grief, because just down the hall from his cell, 12 jurors were deciding if he would live or die. Just before 2 p.m., there was a knock on the door leading to the jury room. The clerk walked to the door, cracked it slightly, and received a folded piece of paper. She read it silently and then looked up. The jury had reached a unanimous decision. The sheriff's deputies ushered Brewer from his cell back to the seat behind his lawyers. The judge returned to the bench, and the clerk opened the rear door. Jurors filed in. The foreperson handed the verdict to the deputy clerk so that it could be read into the record. We, the jury, find that the defendant should suffer the penalty of death. As the clerk's voice faded, the judge ordered Brewer to enter the well of the courtroom. He obeyed. Bracketed by deputies, he slowly stepped forward. The judge began, "Mr. Brewer, the jury of citizens of Lowndes County, Virginia, have found you guilty of the crime of capital murder. The jury has returned that verdict in open court. The verdict is that you should suffer death. Do you have anything you desire to say?" "No," Brewer responded softly. "I am by law required at time to set the date for your execution. I hereby direct that the sheriff immediately take custody of your body and transport you to the maximum security unit of the Mississippi Department of Corrections at Parchman, Mississippi. You are to remain in custody until May the 12th, 1995, at which time you will be removed to a place where you shall suffer death by lethal injection," the judge said. "May God have mercy on your soul." Obviously, that didn't happen. Brewer filed, had his appeals. He went through a number of attorneys during his appellate process. The first 2 quit on him. The third was an interesting case. It was a black lawyer in Mississippi who took a lot of cases nobody else would take, but also, unfortunately, was admirable for his efforts, but was not a particularly good attorney. And it wasn't until Brewer, well, there's a scene in the book actually that's kind of heartbreaking where Brewer is sitting in his jail cell and he's gone through several attorneys, most of whom never bothered to talk to him. And he writes this letter to his then attorney and asks him if he could have, I think it was $60 or a typewriter, because he's decided to learn the law on his own because he can't rely on his lawyers. And he doesn't get the typewriter, but he finally gets a pen and some paper and fires off a letter to the Innocence Project in New York, and then took on his case and ended up saving his life. All right, so the last section I'll read is about Levon Brooks. As I said, Levon died about a month before the book came out. This takes place in 2015 when I went down, just spent some time with Levon and his family. So this is after Levon's been out for about 7 years. After Levon and Kennedy were exonerated, the state did pass a law to compensate people who have been wrongly convicted. So Levon and Kennedy get $50,000 a year for each year they were incarcerated, up to $500,000. So they get it for about 10 years. So I guess Kennedy's is probably expired now. So this takes place, this is at Levon's house. "I'm happy," says Levon Brooks. He's sipping from a Sprite bottle filled with rum. "For the first time I can remember, I'm happy. It's a cool afternoon in December 2015. Levon and Dinah Brooks live in a trailer between Brooksville and Columbus, Mississippi. They met while he was in prison. She worked in the cafeteria. Brooks had proposed years ago but never seemed interested in setting a date. Dinah ribbed him for that. Behind their house, a menagerie of hunting dogs, chickens, rabbits, and other animals bark, cluck, bay, and scurry around in their coops. Friends and neighbors stop by, sometimes to stay a while and chat. The place bustles with life. Most who meet Brooks are immediately struck by his presence. Ed Blake, the DNA analyst in California who worked on Brooks and Brewer's cases, recalls the first time he met Brooks. He's not a big man, Blake says. There are some people who simply have a look about them that commands one's attention, and Levon Brooks is one of those individuals. He hardly has to talk to you before you're drawn to him to engage in a conversation. His charisma, his dignity simply flow. Brooks's declaration of happiness becomes all the more poignant a few minutes later when he lifts his shirt to reveal the pump that's sending chemotherapy through his body. He was diagnosed with stomach cancer in 2014, but he has good doctors in Mississippi, and the Innocence Project put him in touch with a leading oncologist in New York. His prognosis is good, which obviously it wasn't. On this chilly afternoon, Brooks is dressed in a t-shirt and camouflage pants, and his hair is in braids. He offers his guests some deer jerky, then shows off his new rifle. "Did you hear about Allgood?" he says. Forrest Allgood is the prosecutor who convicted him, and Brewer for that matter. "I campaigned for the new guy. I think I like him," he says, and he flashes a Cheshire smile. Allgood, after about 25 years in Mississippi, was finally defeated in his re-election bid 3 years ago. So that's where that comes from. When asked if he holds any resentment for the men who convicted him, Brooks points out that Allgood apologized to him on the day he was released, but the two haven't spoken since. Not that necessarily would have been friends under different circumstances. Noxubee County is a small, close-knit community, but it's also largely segregated. So what about Deputy Eichelberger? Has he apologized? So Eichelberger was the one who took the lead in investigating the case and basically sort of honed in on Brooks early on. And I love this about how he apologized. So what about former Deputy Eichelberger? Has he apologized? Not in words, Brooks says. He doesn't talk much. But he did give me a hunting dog after I got out. I think that was his way of saying he was sorry. We hunt deer together sometimes. Within about 10 minutes of meeting Brooks, odds are pretty good that he'll ask if you want to go hunting with him also. He just assumes you'll love it as much as he does. Since he got out, Brooks has also been on the receiving end of more than a few such invitations. One came from his old childhood friend, Boswell Stevens, the foreperson of the jury that convicted him. Boz Stevens also happened to be inherited the plantation that Brooks's parents sharecropped on, and then served as the foreperson on Brooks's jury. Stevens has since come full circle. In a way, so has the plantation where he and Brooks grew up. Stevens' mother died a few years ago, but since then the farm has been rented out to contract farmers. Shortly after Brooks was released, Ashley Smith, the sister of the victim, apologized to him too for identifying him as the man who abducted her sister. She didn't need to apologize, of course. He never blamed her. Courtney Smith's father, Rocky Allen, also apologized, though he too had no real reason to. "It troubled me all this time," he told Brooks. Some 25 years ago, Brooks left the job he loved at the Santa Barbara Club to clear up any misunderstanding with the Noxubee County Sheriff's Department. He told his friends he'd be right back. He never returned. Now, with some of his wrongful conviction money, he's back in the entertainment business. He and Dinah have opened a cafe behind his house. They named it D&T's Hill City Hideaway. The modest, cozy spot serves up fried food, soda, and beer. Baseball caps and saggy pants aren't allowed. On Saturday afternoon, they show college football, and at night they dance. Early last summer, the Hill City Hideaway hosted a wedding, that of its owners. Levon had finally come around. A photographer from New York had become a good friend, drove down to shoot the affair. The weather was hot, and the dress was casual. Dinah wore a pink chiffon dress. Levon wore white head to toe, a white hat, white linen, white jeans, and white leather cowboy boots. There was a lot of dancing. I'm not going to keep reading to you, so you have a reason to buy the book, but be happy to take any questions people have. Yes?
I enjoyed your comments in the book on forensic science, which is really not an outgrowth of pure science, but actually is as a result of the criminal justice system focusing on ways of convicting people and finding ways to investigate crime. And whereas the scientific discipline is a question of hypothesis testing, and erroneous, and that's how science progresses, whereas in forensic science, it's all about getting a result, getting a conclusion, confirming a conclusion. And what I was particularly interested in is how Dubious and how the Supreme Court's articulated standards on introducing evidence has really kind of misdirected the whole inquiry in science as a part of law. Could you kind of elaborate on that a little bit? Because
I could elaborate all night on that. As you say, forensics really evolved out of the law enforcement community and evolved as a way to help police and prosecutors solve crimes and win convictions. It was not developed in the scientific community, so it has never, most areas of forensics, particularly what they call the pattern matching disciplines, have never been subjected to any real scientific scrutiny, or at least not up until about 5 or 10 years ago. And so for a long time, the scientific community and the legal community didn't interact a whole lot. We get into this in the book. There's an interesting history behind this, but there's a lot of tension between the medical community, particularly between coroners and medical examiners. But because of this, forensic science sort of filled this void in the criminal justice system and was never kind of scrutinized by the actual scientific community. And what then happens is in the early 90s, we get DNA testing, which does come from the scientific community, and it shows that we're getting a lot wrong in the criminal justice system. And it shows that a lot of these forensic disciplines that we thought were foolproof really aren't. And so we start getting a lot of the testing. Science starts taking interest in the criminal justice system, and we start getting some of these forensic science commissions. One of the first sort of areas that they really jumped into was arson investigation. It was the Cameron-Willingham case in Texas, and we find that, there's just, my wife has actually done a lot of research in this area, that like a lot of the arson investigation sort of methods and protocols were just based on sort of, I don't know, old wives' tales and like urban legends. And I mean, it's crazy some of the stuff that they relied on. And all this time, so the Supreme Court, for a long time, I mean, a lot of lawyers in this room, so I'm sure you know about the Frye standard. So for a long time, most courts in the country, when expert testimony or sort of scientific testimony would be challenged, they would apply what they call the Frye standard, and this was from a DC Court of Appeals opinion in the 1920s. Basically, it says if the expert testimony is sort of accepted within the community within the sort of the expert community from which that testimony would come from, then it's going to be acceptable. And what Daubert did, or when you're in areas with French influence, they call it Daubert, is it kind of expanded and narrowed Frye at the same time. But what we sort of conclude in the book is that it allowed more testimony in so long as you could sort of make some sort of claim that you were certified in some way. And it gave rise to this cottage industry of certification mills that sprung up all over the country. And a lot of these, Dr. Hayne, for example, in Mississippi, was not certified by the sort of gold standard for forensic pathologists, which is the American Board of Pathology, but he was certified by some of these sort of fly-by-night groups where, one of them was based in Vegas, one of them One of them was this crazy group that was founded by this guy who recently passed away, but he was a college professor, had twice been fired for plagiarism, and so he decided to start his own forensics group, and Hayne is certified by them. But it created this kind of false sense of security in the courts, and one of I think the really kind of destructive thing that comes out of both Frye and Daubert is that the courts, the Federal Court of Appeals, DC Federal Court of Appeals, and then the Supreme Court, they make judges the gatekeepers of science. And the problem with that is that judges aren't trained scientists; they're trained in law. And when you read analysis in a Daubert hearing, they read like exactly like you would expect a judge to do a scientific analysis, which is they look to what other courts have done. And it's like, if in science, if all of science was sort of just looking to what scientists had done in the past, science wouldn't move anywhere, right? And so it's a really good illustration of this problem of two very different ways of seeing the world, and we're trying to sort of harmonize them in some way, and it's just not working. So, for example, I'll give you a good example. I mean, one of the forensic experts I interviewed for the book talks about, he says he also teaches philosophy to undergrad students, and he says, he'll teach syllogisms to them, these sort of logical kind of puzzles. And he says, when he reads a judicial analysis in a Daubert case, a Daubert hearing, it reads like undergrads approach these syllogism cases, which is that they start knowing the answer and they work back from there. And it's sort of like these judges, they know what they want the conclusion to be, and then they sort of try to find some scientific sounding way of backing it up. And bite mark evidence is a great example. I mean, we go through the history in the book, but it all goes back to this one case in California, which strangely is called Marks, M-A-R-K-S, or M-A-R-X, I'm sorry. And it was this California appeals court. It was a bite mark case. It was a weird case where like the dentists who testify were like biting one another on the nose to like try to compare it to the crime scene, the crime bite. But the court actually concludes that there is no science behind bite mark matching. But what they do say is there doesn't need to be any science because it's just sort of common sense. Like we looked at the marks and what they call the eyeball test. And what then happens is then all these other courts start citing back to Marks, but a really curious thing happens. They cite back to Marks, and they cite that Marks has already concluded that bite mark matching is scientific and passes every sort of science test. But that's not what they did. And this has become, you get this big game of sort of this judicial echo chamber, or what kid used to call telephone, right? Where the courts just start citing one another, and nobody actually goes back and like looks at the actual analysis. And I mean, there are hundreds of cases where bite mark evidence has been let in where it shouldn't have, and I think we're up to almost 30 cases now where someone who's either arrested or convicted based on bite mark evidence has since been exonerated. But it's not just bite mark evidence. I mean, it's making judges the gatekeepers of good and bad science has been a really bad idea, because what they tend to do is they look to whatever other judges have done, and if it's a case of first impression, no pun intended with bite marks, They tend to err on the side of just letting it all in and letting both sides have their own experts sort of hash it out and let the jury decide. Well, the problem with that is there's a phenomenon called the CSI effect, and it's actually prosecutors who you hear complain about it more than defense attorneys. But there's this idea that juries, because of shows like CSI, juries want sort of definitive, hard. They want witnesses to say this is what happened, or this is who did it, this is who didn't. And most scientists, conscientious scientists don't speak in those kinds of terms. They speak, they talk about probability, they talk about margin for error, and juries don't want to hear that. The problem is when you get an expert who is sort of discredited enough or not credible enough, who's willing to give them that kind of certainty, they can do a hell of a lot of damage. And so the ironic thing sort of is from the perspective of a jury, the more scientific an expert witness is, usually the less persuasive and convincing they are to a jury. And so that's the problem with the let it all in approach and sort of let the adversarial system work it out, is that the problem with that is that the more scientifically sound the testimony, the less likely the jury is probably going to buy it. And West is a great example of this. Juries loved Michael West because he had this trademark phrase he used, indeed and without a doubt. And there's no scientific research or standards or anything behind that phrase. It's just something he made up. But juries loved it, and they loved that kind of certainty. It's a long-winded answer to your question, but Yes, we'll go here and then in the back. Yeah.
Can you explain the process in Mississippi that would allow this one doctor to do statewide all of this work? That sounds
Right.
impossible geographically.
Right. So the way the system was set up, so and this was actually the case in Alabama for a long time too, although you guys reformed your system way before Mississippi did. And actually, it's the case in most states for a long time. So the way the coroner system was set up is there's a suspicious death in Mississippi. You know, either if the local coroner suspects that it's a crime or death by negligence, they would usually get together with the prosecutor or the sheriff, the local chief of police, and they would send the autopsy off to a private doctor on a contractual basis. And the coroner, in Mississippi, the coroner ultimately has the authority over the crime scenes and the body, but the way it ends up working out is the coroner tends to be a pretty low-ranking position. It's usually the prosecutor that calls the shots.
Qualifications by law now. They're pretty sophisticated.
That's right. That's right. In Mississippi, so to run for county coroner in Mississippi, you had to meet two qualifications. One is you had to have a high school degree, and that one was pretty negotiable, actually. There were lots of them that couldn't read. And the other one is you have to never have denied the existence of a higher power. North Carolina had that second one, and they also had you could never have participated in a duel. So lots of the coroner system is a crazy history. But the way the system in Mississippi worked though is you would contract the autopsy out to a private doctor. Well, if you're a prosecutor, the way that the kind of incentives fall then is let's say you're pretty sure you know who did it, and you're pretty sure you know how they did it, and you tell the private doctor that, and the private doctor comes back and says, nope, that's not how it happened, or more likely says, there's just not enough evidence for me to say either way. He's probably not going to get your next autopsy referral, right? Or maybe he will, but if you're somewhat corrupt or you just want your job to be easier, you'll probably look for a doctor who's going to be more sort of amenable
Too many questions.
to what you want him to say. And you don't have to be corrupt for this system to for the incentives in the system to take hold. It might just be something that you're going to sort of migrate to the doctor who kind of works with you and tells you what you need to hear. And so Hayne told prosecutors what they want to hear, and so over the years he just slowly kind of dominated. Actually, it didn't take that long. It took 4 or 5 years. There was a guy before him named Rodrigo Galvez who got about 60 or 70% of the autopsies in the state. But Hayne, he started in 87 or 88. By the early 90s, he was up to 75 or 80% of the autopsies in the state.
He became a medical examiner, but then he didn't want to take the pay cut and quit, didn't he?
Right, and he wasn't board certified, so he couldn't hold the position permanently. He was named interim state medical examiner.
What about the board certification test that he walked out on?
Yeah, so he took the board certification test by the group that certifies everybody, the sort of gold standard, and that the state of Mississippi requires if you're going to be the official state medical examiner, and he failed it. When he was asked in testimony under oath over the years, dozens and dozens of times, he insisted over and over again that yes, he failed it, but he failed it because he found the questions insulting, and he got up and walked out because they were insulting to his intelligence. And so the opposing attorneys would say, well, give us an example. And he could only give one example, and he gave the same example over and over again, or versions of it. And that was, he said, well, they gave me a series of colors, and they asked me to rank the colors according to their association with death. And he's like, I just found that absurd and insulting, and I got up and I stormed out, furiously stormed out. And that story never made a whole lot of sense because, one, he flew to Chicago from Mississippi to take the test. So he paid for a plane ticket. You had to pay $1,500 just to take the test. So he's really going to throw all that away because one question insulted him. Just never made a whole lot of sense. But he kept saying that over and over and over again until finally in, 2013, 2012, an attorney actually got a hold of the test that he took. And that question wasn't anywhere on the test. He was given, first a reporter got it but wouldn't show it to him, and he didn't believe them, and he said, I would stake my career and reputation on the fact that question is on there. And then they showed it to him. And it's like, well, I don't know. It's like, I remember it being on there. I can't explain it.
There were more than one test given out that year.
Yeah, well,
you said there could have been multiple tests.
But they had his actual test, the one he took. So he perjured himself. He lied over and over and over again, and that was never because he was lying for the right side, it was never really held against him. But so getting back to your question, so that's the system that kind of allowed him to dominate. Now then there's the sheer sort of physics of it, right? How is he able to do 1,800 autopsies per year while testifying 3 to 5 times all over the state? I mean, he was driving, I mean, we have records where we can show one of a typical day for him, and it's like crazy. It's like he gets up in Jackson, he, goes up to the Delta and testified, he goes down to the Gulf Coast and testified, and he goes back and does 6 autopsies that day. I don't know how he did it. I mean, there's speculation that he didn't do all of his autopsies, that he had, staff and assistants, probably Michael West do some of them for him. There's speculation that he, well, we know that he did a lot of them very sloppily. I mean, they're
Randy Cheney's spleen test?
Yeah, there's a case where he carefully noted the weight and appearance of a decedent's spleen. Unfortunately, the spleen had been removed 4 years earlier. There's a case where he weighed and noted the appearance of the decedent's ovaries, and it turned out it was a male. So there were cases where he clearly got sloppy over the years. But I don't know how he did that many, while holding down 2 full-time jobs and testifying all over the state, and consulting in private cases. That's where he made a lot of his money, is in civil cases. He did a lot of medical malpractice cases, wrongful death cases.
And now he's doing criminal defense.
Right, now he's in criminal defense. And actually, it was kind of brilliant of him to take on those cases. One, he made a lot of money, but 2, and we talk about this in the book, in Mississippi, and probably clear here too, a lot of the public defenders, whether for the county or for an individual city, you get $4,000 or $5,000 to be the public defender for your town. So most of the public defenders have a private practice, and most of them are, trial lawyers. They work for the plaintiff's bar. And if you're in the plaintiff's bar and you have a wrongful death case, a medical malpractice case, you need an autopsy done, Hayne was the only game in town. And so he'd positioned himself where the prosecutors and the coroners all loved him because he helped them get convictions. But if you're a public defender in a murder case, are you really going to attack this guy's credibility if you need him in the cases where you're actually making your living, all these civil cases? And so he kind of brilliantly positioned himself in a way that, nobody really had any incentive to go after him. The one exception, and this is where you really see he gets grilled in depositions, are the civil cases, the opposing counsel in the civil cases. So in medical malpractice cases, you see attorneys for doctors just absolutely grilling him in hospitals. And those cases, probably not coincidentally, are almost always settled before they ever get to trial. In the back there. And then I'm sorry, I skipped over.
Today, I mean, what's West doing? What's the other fellow doing?
So West basically was, they finally had some shame and stopped using West in about 2003, 2004.
Practicing dentistry?
He's practicing dentistry at a prison in southern Mississippi, which is kind of perfect. But he there are still 2 people on death row, one in Mississippi and one in Louisiana, who are there almost exclusively because of West's testimony. And so in both of those cases, the state is still defending convictions that were won in his testimony. And this is so telling. I mean, Jim Hood, the Attorney General of Mississippi, has admitted now that West, is a fraud. And in fact, he claimed about 6 or 7 years ago that he had just started an investigation into West. I haven't heard anything about it since. But they're still defending convictions that they won based on West's testimony. But they don't defend his testimony anymore. What they do say is that in all these cases, we're talking, this is well into post-conviction. And so basically what the state argues in these cases is that the defense has already challenged West's testimony earlier, and they're procedurally barred from raising it. So to basically arguing that these people should remain on death row on a technicality, but that they won't defend West. So Hayne was basically fired from doing any more autopsies for prosecutors in 2009. The coroners then had a little revolt and tried to bring him back, but the legislature stopped them. But he was still allowed to testify in any case where he had already done the autopsy but hadn't come to trial yet. And it turned out his backlog, he had about 700 cases in his backlog. These were cases where he had done the autopsy but hadn't issued a report yet. And then any time somebody was given a new trial, where he did the autopsy, he could testify in those. But he wasn't barred from testifying.
Is he still practicing medicine?
He's not only still practicing medicine, he now testifies for defense attorneys in the state, which he never did before. But as soon as he was fired, he fired off a letter to defense attorneys across the state. And then he continues to testify in civil cases.
How much did he make off the state? I saw a number mentioned in the back report.
It's really hard to say. I mean, he made
Hayne.
Hayne, yeah. So at the beginning of his career, he was getting, it actually wasn't that much per autopsy. He was getting about $500 per autopsy plus $200 an hour to testify in court and for preparation and testimony. And then he would get extra for any sort of lab work or anything, and additional stuff he had to do from autopsies. By the end of his career, they were paying $1,000 an autopsy plus I think it was $350 per hour for testifying in court. I mean, we put an estimate in the book. I think we estimated he was making somewhere in the height of his career, somewhere around $2 to $3 million per year from the state, and then an extra probably $2 or $3 million from his private autopsies. But the money, there's a whole section in there on his finances, which are just crazy. He was working with this guy named Cecil McCrory. They'd started a business together to basically just to kind of launder all the money that Hayne was making from all this stuff. And McCrory was indicted 3 years ago in the biggest public corruption scandal in Mississippi history. Basically, I'm sure you read about it. The head of the Mississippi Department of Corrections was also indicted. I think they ended up being hundreds of millions of dollars in prison contracts that McCrory had been sort of selling, bribing state officials to sort of send to his companies. So this was Hayne's longtime business partner. Now Hayne wasn't directly implicated in that particular scandal, but this was his longtime business partner. And in depositions, when people are trying to nail down where all the money went that Hayne had made in all these private autopsies that he was doing, because he'd make a lot more money in the private cases per autopsy than he did in the state cases. It's just the testimony is bizarre. Like they would claim that they donated it all to charity, but it was like charities that there were no public records. Yeah, so they claimed over and over again that he would just pay the full college tuition of random students who needed it, but they couldn't name any of them. And also, he wrote the check directly to the students instead of to the college because he didn't want the students to think he didn't trust them. But he couldn't give you any names. But he was just that generous. Like people would just come in, a student would just come in and say, "Hey, I need money for books," and Dr. Hayne would write him a check. And it was like, he apparently was just giving out money hand over fist, but there's no record of any of it. He would give it out in a way that there's no paper trail conveniently. So yeah, the finances are tough because it's he claimed to give a lot of money to political campaigns, but he couldn't name which ones. And
you said Hayne was doing around 80% of Mississippi's public autopsies over the span of 15 to 20 years. He grossed well over $10 million from the taxpayer.
Yeah,
that may be conservative.
Yeah, that's a very conservative estimate. And the whole time he was drawing six-figure salaries from these two hospitals that he worked for.
He did one in Louisiana as well, didn't he?
I don't know if he did one. Well, he was doing autopsies in Louisiana too. So he had monopolized the autopsy referral system in Mississippi, and then for about 10 or 12 parishes in northern Louisiana as well.
Tell them about the sting. Actually,
let me get. There's two more questions. You had your hand up a while ago.
Well, I was just thinking about some of the things you were saying about the difference in my layman's interpretation. If people in the legal realm focus on what man-made, in other words, man-made code or laws, whatever, and then people in science focus on what God made, and there's this difference here, and then people who write mystery novels, creating fictions, and Sherlock Holmes, of course, and that ties into what you're saying about CSI and all this. And I'm wondering, I'm not a lawyer, so I don't know all the procedural stuff, but in what percentage of these cases was there an actual jury involved? Because that's where I see sort of maybe the CSI or Sherlock Holmes thing tie in, where a jury, can be swayed by their love of the mystery books and this belief that we can have proof that this is exactly what happened. And,
right.
And I'm kind of wondering what number of systems of checks and balances could break down for this, frankly, incredible record that you're.
Yeah, I mean, yeah. So a lot of almost all of these were jury trials. I mean, the criminal cases were all jury trials. And West was very persuasive to juries. He was folksy. He was, he sounded really smart, but he didn't put on airs. So they found him very likable. And whereas the defense witness was usually like somebody they flew in, from the East Coast, and the prosecutor would portray them as sort of this gun for hire that was coming in to, and West was just like a local boy. He was just trying to do good and put the bad guys away. I mean, it was very The jury, he really went over juries that way. Yeah, the country dentist. He would call himself, he would say, I'm just a little old dentist from Hattiesburg. And he would say, but basically, I'm just a humble guy who just happens to be really smart, but, I don't show it. And but I'll tell you, we talk about this in the book. There's a guy named Christopher Plord, is a defense attorney based in Arizona, had a client named Ray Crone, who was actually twice convicted on bite mark testimony and exonerated by DNA testing in 2000. And Plord was angry. He was pissed about this because this guy did 10 years. He was almost executed. And it wasn't West didn't testify in that case, but Plord decided he wanted to sort of expose bite mark matching for the fraud that it was. And so he picked West because at the time West had kind of been exposed by them, but he was still being used, and he was still kind of a superstar in this field. And so Plord, I love this story. He takes the crime scene photos. In this case, the victim was pretty clearly bitten. There's a bite mark on her breast. And so he takes the crime scene photos and sends them to West, along with a dental mold from his own private investigator. And so he sends a letter and a check for West's retainer, and he says, I'm an attorney for the family of the victim. Here's a crime scene photo of the bite, and here's a dental mold of the person we think did it. Can you match these up? And West not only says he can match them up, he sends back a 50-minute video where he meticulously goes through his methods and explains. I think he said it was the odds of anyone other than this suspect leaving this mark are astronomical. And if you watch that video, he uses really technical sounding words. He sort of matches. He blows up the photo and he matches the mic, and he uses these phrases. I can't.
Is he wearing the goggles?
He's not wearing the goggles in this one because he can only do the goggles when you have the actual body in front of you. But you watch that video, and if you didn't know that, pardon my language, if you didn't already know he was full of shit, when you're watching that video, he's very convincing. He's I could see how juries would, if you weren't sort of pre-exposed to this kind of stuff, how you might find him to be, extremely convincing. But even after that video came out in 2000, and clearly he's a fraud, right? There's no way that this attorney's investigator committed the crime, right? And yet, even after that, the Mississippi Supreme Court, 2 years later, in fact, I believe it was the Eddie Lee Howard case, somebody challenges West, a death row inmate actually challenges West's testimony, bite mark testimony in his case, and the Mississippi Supreme Court rules they have the video in front of them, and they have this sting in front of them where West exposed himself to fraud, and they write, just because Dr. West has been wrong in the past doesn't mean that he's wrong in this case. And it's just mind-blowing. What more do you need, And, we finally, for the book, we interviewed the Chief Justice of the Mississippi Supreme Court for that case, and who was there for most of these two guys' reign in Mississippi. And, he's in his 80s now, to his credit, he says, we screwed up. He said, we were way too deferential to these guys. We were sort of caught up as kind of the heyday of the 90s, and there's a lot of death penalty fervor, and we just didn't look skeptically at this kind of stuff. And it'd be nice if he had reached that conclusion while he was still on the court, but it was nice of him to give us the interview and sort of come clean on all that. You got a question?
Yeah, you spoke about the two death penalty cases where people are still in prison for it, and they were in Mississippi and Oklahoma?
Louisiana.
Are there any links to Alabama, to people that are in prisons currently? Obviously not for death.
So Hayne, Alabama has a pretty good death investigation system, certainly compared to Mississippi. And so Hayne, I don't think he ever testified here. Maybe in some civil cases, but I don't think he practiced here for about 3 or 4 years before he moved to Mississippi. But I don't think he did any autopsies here. So the only real connection to Alabama is Emily Ward and Leroy Riddick, and then also a guy named Jamie